Ready? Start. The appeal must be allowed on the short ground that there being a threat of eviction by a person claiming title paramount, that is head lesser Krishnamurthy, the appellant was not stopped under section 116 of the Evidence Act from challenging the title and his right to maintain the eviction proceedings of the respondent as the lesser. Section 116 of the Evidence Act provides that no tenant of immovable property shall during the continuance of the tenancy be permitted to deny that the landlord of such tenant had at the beginning of the tenancy a title of to such immovable property. Possession and permission being established, estoppel would bind the tenant during continuance of the tenancy have been interpreted to mean during the continuance of the possession that was received under the tenancy in question, and the courts have repeatedly laid down that estoppel operates even after the termination of the tenancy, so that a tenant who had been let into possession cannot dispute the title of the landlord at the commencement of the tenancy. The rule of estoppel is thus restricted not only in extent but also in time, that is restricted to the title of the landlord and during the continuance of the tenancy, and by necessary implication it follows that a tenant is not stopped when he is under threat of eviction by the title paramount from contending that the landlord had no title before the tenancy commenced, or that the title of the landlord has since come to an end. Having heard learned counsel for the parties and after perusing the orders passed by the rent controller and appellant authority, we find they concurrently held that the denial of title by the appellant was not bona fide and the default was not willful. They also held building is required for demolition and reconstruction. Challenging these findings, the learned counsel for the appellant argued with vehemence that the authorities below should not have addressed itself into the question of title, as it had no jurisdiction to decide the question of title. Hence, approach of the appellate authority was against the jurisdiction vested in it under the law. There is no dispute of this proposition, neither it is disputed by the learned counsel for the respondent, nor this question of title has been decided in these proceedings. It is only when a tenant denies title of the landlord, the court has to scrutinize the evidence and come to the conclusion prima facie whether the denial of title is bona fide or not. It is in the context of course, court has to go into evidence to test the veracity of this denial of title. Thus, any finding in this regard could not be a finding on the question of title. There is neither any claim of title set up by the respondent, nor there is any such issue between the parties in these proceedings, and hence recording of any finding in this regard is only to be understood for a limited purpose of testing the bona fide of tenant to deny the title of the landlord. What has to be considered in a case of denial of title by a tenant is whether there still exists any relationship of landlord and tenant inter se, as in the present case, between the respondent number 1 and the appellant. In other words, by such denial of title does liability to pay this rent to such landlord ceases. Full stop.